Yes, good morning to everybody. Here I put the slide of the good morning, and I was dealing about the rules of construction, that is the primary rules. So we covered the earlier the lettered construction, golden construction, mischievous construction, purposive construction, beneficial construction, strict construction of the tax statute, strict construction of the penal statutes, and this class harmonious construction we'll see. So let me start it because now the time is 11:32. People are joining one after another. Yes, I saw their messages also, and I'm sure that you are hearing my voice and you are. You could also see the what I said. Put it on the screen. I think that you are in a position to see the screen, isn't it? Yeah, if the answer is yes, then I will go to the next slide, which is says about as participants are joining one after another. Yeah, next slide. If I could see the screen, that is what is actually the harmonious these days. Harmony, not that you don't think that harmony means that harmony, sarigama harmony instrument. Of course, that is also a harmony. Harmonize the things. But here, harmonious means taking together, rather, we can say. If you see the rule of harmonious construction is the thumb rule, THUMB thumb rule, to interpretation for any statute, an interpretation which makes the enactment consistent should be the aim of the courts, and also interpretation which avoid the inconsistency or pregnancy between the various sections or part of the statute should be adopted. So what it actually says, suppose if the two statutes are there, one statute says something, another statute says something, and both are contradictory to each. At that instance, which statute should be taken into consideration for the interpretation? We should not do like the leave one statute and adapt another second statute, and we should not make one statute dead, one statute life. So we should harmonize them. Like a crude example, which I will give you. Suppose before my marriage, let me presume it. My father says, "Don't come late in the night. Come before 9 a.m." Sorry, not 9 a.m. Night means 9 p.m. Yes, don't come late in the night. Come before 9 p.m. That is my father statement. That is one statute. Let me say it. Then after marriage, the second statute, wife says, don't be late. Come before 10 o'clock. That is 10 p.m. in the night. So father says 9 p.m. and wife says 10 p.m. At that instance, suppose if I come at 9:30, then my father feels very bad because his time is 9 o'clock p.m. but I came 9:30, so he will be disappointed. But my wife will be happy because I came within her time 10 p.m. before I came. So if I come 10:30, then the two people, my father will be disappointed and my wife will be disappointed because I crossed 9, I crossed 10 also. So how could I harmonize to keep happy to my father, to keep happy to my wife, both the things? At that instance, to make them both happy, if I come at 8:30, I am sure that both will be happy because I harmonize it here. My father should be happy, my wife should be happy, and both should be happy. At that instance, it is a harmonious construction. The harmony is there, and both are happy, and the work also be done. That is a living example regarding the harmonious construction concern. So we should not disappoint one statute. We should not overlook one statute, and we give the preference to another statute, and we have to together we have to go. So that's why the people say life is a question of adjustability and adaptability. I repeat, life is a question of adjustability and adaptability. So adjustment will be there if there is, and adaptation would be there. Otherwise, life become miserable. So harmoniously we have to take together, and sorrows and joys. Yes, we have to harmonize them, and we have to go, because life will not be always happy, and life will not be always sorrow. So we have to harmoniously we have to take together. So that is about the harmonious construction. So we'll come to the actual point is concerned. Then the yes, this side, and here I put it over there, the interpretation of statutes, and you could see Manner College of Law. So I put it over there. Of course, I could not remove the Law Times Journal. Yes, come to the doctrine of harmonious construction. I make the one maxim, Plato maxim here. No law or ordinance is mightier than understanding. See, understanding is very much important. Law and ordinance not mightier, but than understanding. If you take the understanding of a particular thing or an ordinance, then it is a meaning. Otherwise, if the law is there, if you don't understand it, if the ordinance is there, if you don't understand it, there is no meaning at all. So understanding either the law or the ordinance, if that is not there, then the no law or ordinance is mightier than understanding, Plato says. So come to the introduction and a principle laid down under this doctrine, and go with the judicial decisions, that is the decided cases, later on ending with a conclusion. So I think I would like to complete in this online class. Now the time is 11:38, and I'm sure that people are joining one after another. So please welcome to the class. So in the introduction, the harmonious construction is a principle of statutory interpretation used in the Indian legal system. It holds that when two provisions of a legal text seems to conflict, they should be interpreted so that each has a separate effect and neither is redundant or nullified. So one should not be redundant and nullified, another should be given a life. In other words, the doctrine or the rule of harmonious construction is adapted when there is a conflict between the two or more statutes, or between the parts or provisions of the statutes. As per this doctrine, the courts try to avoid conflict between the provisions of the statutes. The doctrine follows a very simple rule that every statute has made for purpose and specific intent as per law, and it should be read as a whole and interpreted accordingly. Thus, the provisions are so interpreted that the conflict between the two statutes or its provisions is avoided, and each of them is given effect. For this purpose, the scope and meaning of one may be restricted as to give meaning also to the other. So, the aim of the courts are number one, an interpretation which makes the enactment consistent. Number two, a construction which avoid inconsistency or repugnancy between the various sections or parts of the statute. However, in the case in which it shall be impossible to harmonize both the provisions, suppose if it is impossible to harmonize them, at that instance, the court decision shall prevail. The court decision will be prevail over there. If the impossibility to make the two statutes to be harmonized, then the court will take its own decision at the time. So according to Kelly, he is also one of the like Lord Esther, Lord Ashburn, Lord Dennings. So he's in a Kelly, and he says constitutional provisions should not be construed in isolation from all other parts of the Constitution, but should be construed as to harmonize with those other parts. When there are two provisions in a statute which are in apparent conflict with each other, they should be interpreted such that effect can be given to both, and that construction which renders either of them inoperative and useless should not be adopted except in the last resort. So, when the two sections of a different statutes are two different statutes having conflict of each other, and at that time we try to harmonize it, and If harmonizing not possible at all because of the statutes, at that means the court having its own discretion to see which statutes exact meaning should be taken. So doctrine of harmonious construction explained, according to this rule, a statute should be read as a whole, and one provision of the act should be construed with reference to the other provisions in the same act so as to make a consistent enactment of the whole statute. So that is the reason in the middle one should not ask it. See, you hear the total if what the other person says. Later on you can ask your doubts. So that in the same manner, if you totally hear my lecture, later on I will give the chance to you to ask the questions and clear your doubts. So I want to see harmoniously to see that the class should be understood by my students. Come to the point again. Such an interpretation is a beneficial in avoiding any inconsistency or repugnancy either with the sections or between the sections and other parts of the statute. So in this, there is a landmark case of case law is there. Commercial, that is the Commission of Income Tax versus Hindustan Bulk Carriers. In this case law, the Supreme Court laid down five principles of rule of harmonious constructions. So they made the five tenets, five rules. What are those rules? Let me see. If you remember these rules, I'm sure that it is very easy to you to use them when there is a conflict between the two statutes and how to harmonize them. The first is principle is the court must avoid a head-on clash of seemingly contradicting provisions, and they must construe the contradictory provision so as to harmonize them. So there would not be any head collision between one statute to another statute. You see that both should have to be harmonized and taken into consideration in the interpretation. Number one. Number two, the provisions of one section cannot be used to defeat the provisions contained in another unless the court, despite all its effort, is unable to find a way to reconcile their difference. So, what this section says over there, means this principle says, if one section will contradict with the another section, and at that in the same statute or a different statute, at that time we try to resolve them. If the resolving is not possible, unable to find a way to reconcile their differences, then court is having its own say. The third, when it is possible to completely reconcile the difference in contradictory provisions, the court must interpret them in such a way so that effect is given to both the provisions as much as possible. That is the try to make them happy. So one should not feel unhappy, another should not feel another happy. In another sense, one statute should not be curbed, another statute should not be taken out, and both statutes or provisions should be taken together and given a meaningful to resolve the conflict. Then the next point is the fourth one is court must also keep in mind that interpretation that reduce one provision to a useless number or a dead lumber, here lumber means like a timber, is not harmonious construction. So in any case, we should not say that one statute we should could make a lumber or a timber, make a dead, and another to be active. That is not the way of harmonious construction. And the best way is keep in mind the two interpretation, reduce one provision, uh, should not reduce one provision useless and did another provision active. We have to take two provisions together and see that a good result would come out. The last point is to harmonize is not to destroy. See, we are saying harmonize. That doesn't mean to want to destroy one statute or one statute provision or any statutory provisions are to render it loose. And we should not make it a loose also or destroy also. And both we have taken together and lead. In other sense, these provisions are like two wheels are necessary to run the cart. So two wheels should be on the right track. See, one wheel is small and another wheel is big, then the naturally cart will not go. So equal weight should be given that for the two statutes, like equal shape would be given there for the two wheels, then the cart will go in a smooth way. So the principle is illustrated in the case of here we'll see the case. so that we could understand what actually the harmony is concerned. In the case of Raj Krishna Bose versus Vinod Kanungo, they say Vinod Kanungo, but it might be Calcutta, I believe, Vinod Kanungo, uh, and others. In this case, two provisions are there. The first provision in the Representation of People Act 1951, which are in apparent conflict or brought forth. If you see the section 33 subsection 2 says that a government servant can nominate or second a person in election, but in the same act, another section says, that is section 123, subsection 8 says that a government servant cannot assist any candidate in election. See, if you see these two sections, and each section of the same act will be contradictory to each other. Section 33 2, I repeat, that a government servant can nominate or second a person in election. But in the section, another section says the government servant cannot assist any candidate in election except by casting his vote. That is the second section of the same statute says. The Supreme Court observed that both these provisions should be harmoniously interpreted and held that, they said, a government servant was entitled to nominate or second a candidate seeking the election in state legislative assembly. So now both the things should be harmonized. So this harmony can only be achieved if section 123 subsection 8 is interpreted as in this way, like this: the government servant the right to vote as well as to nominate or second a candidate, and forbidding him to assist the candidate in any other manner. That means he can having a right to vote, and he can also having the right, as well as nominate or second a candidate, and forbidding him to assist the candidate in other manner. So the two things there, he can having a right to vote, and he can second a candidate also, but he is forbidding him to assist the candidate in any other manner. So now it is harmonized both the sections, and they have given. The court stated that it is usual then one section of an act takes away what another confers. To use a non-obstant clause, and say that notwithstanding anything contained in section so and so, this or that will happen. Otherwise, if both sections are clear, there is a head-on clash. It is the duty of the courts to avoid that, and whenever it is possible to do so, to construe provisions which appears to be to conflict, so that they harmonize it. So whenever there is any provisions are there which are contradicting to each other in the same statute, the two different sections, we try to harmonize them and see that good effect should be given. That is the intention of the parliament, intention of the court. Of course, parliamentarian also having the same intention might be. That's why they framed it. But when we are interpreting it, we will see that both are contradictory to each other. Then the court will interfere, and they will try to harmonize the section of the same statute with the another section, and the outcome is harmonized construction existence is there. So this is also a rule, the principle. What is the general principle of the primary principles, we can say this also. So in the words of the apex code, the court should avoid a head-on clash. Always try to avoid the head-on clash, and that is not the quite good way. The consistency should be presumed and should not be assumed, and that what is given with one hand by the legislature would be taken away by the other provisions. No, we should have to, the legislature give one hand, and in another section it is taken away. It will not be the intention of the parliamentarians also. And the principle of harmonious construction should be applied to statutory rules, and the courts should avoid absurd or unintended results. It should be in consonance with the intention of the rule makers, and the rule harmonious construction is applicable to subordinate legislation also. So it is not only applicable to the principal legislation, it can also be applicable to the subordinate legislation and rules and regulations when they are contradictory to each other. We will see in one of the case law, that is the Commissioner of Sales Tax, that is MP versus Radha Krishna, under section 46 subsection 1, the C of the Madhya Pradesh General Tax Act. I know that is 46 subsection 1 only. In the 1958, criminal prosecution of the respondent partner was sanctioned in this case by the commissioner. Then, after repeated demands, the assessee did not pay the sales tax. So, when an assessee did not pay the sales tax after repeated demand, at the time, a penalty will be imposed under this section. The criminal prosecution will be taken against the person who did not pay the tax, the sales tax. The respondent challenged this provision on the ground that there were two separate provisions under the Act, namely Section 22, 4, capital A, and Section 46, subsection 1, C, under which two different procedures were prescribed to realize the amount due, but there was no provision of law which can tell that which provision should be applied in which case. So two provisions are given in a contradictory way. So which should be applied, which should not be applied, it is not given. Then at that instance, according to the primary rule of the harmonious construction, the Supreme Court, the provision prescribed under section 46, subsection 1, C, small c, was more drastic, and it was held that by harmonious construction of these two provisions, the conclusion drawn in that commissioner had a judicial discretion to decide as to which procedure to be followed in which case. So the two different provisions are there given over there which are contradictory. At that instant, the discretion is given to the commissioner at which instance and what interpretation should be taken. So judicial discretion to decide as to which procedure to be followed in which case. It is the commissioner's discretion. Whenever the commissioner will fail to act judicially, suppose the commissioner will fail to act judicially, the court will have the right to intervene. However, in this case, the commissioner had correctly decided that the more drastic procedure under the 46(1), subsection 1, and clause C, small c, deserved to be followed because of the failure of the SSC firm in paying the sale tax despite the repeated demands by the sale tax officer. Suppose if the sales SSC will not pay the sale tax, then he should have to follow the drastic procedure of the criminal prosecution. That is the way that you have to make it out for the people, those who are avoiding their taxes, sale tax is concerned. Of course, now sale tax and central tax and customs, these are all not there. Sorry, not customs, excess duty. So in its place, it comes the GST now. So GST will run it. So if you see the another case, Larry Kerala Education Bill case, 1957, that Supreme Court uses the rule of harmonious construction and ruled that there is an inherent conflict between the fundamental rights and directive principle of the state policy. Suppose there is an inherent conflict between the fundamental rights and directive principle of state policy at that instant, and at that time, they constitute a comprehensive and a social administrative program for a modern democratic state. So they are in the fact supplementary and complementary to each other. So they are not head-on collision. They are supplementary and complementary to each other. Therefore, one has to make efforts as far as possible to avoid any conflict among them. Here, both the fundamental rights and the directive principle of state policy. They are the supplementary and complementary to each other, and that outcome should be taken. They run parallel to each other, and none is subordinate to other by following the doctrine of harmonious construction or interpretation. Here, fundamental rights also given the preference, and a directive principle of state policy also given the preference, and both together will harmoniously will run. That is such an interpretation we have to take it. If two interpretations of the law are possible, if one interpretation violates the harmony between the two, while the other reinforces the harmony, naturally the later interpretation shall be accepted over the former. I repeat, if two interpretation of law is possible, and with one interpretation violates the harmony, it violates completely the harmony between the two, while the other reinforces the harmony, means other provision or other section or other statutes reinforce the harmony, then later means that which reinforces the harmony shall be accepted over the former, which is taking away violate the harmony. So if you take the another point, however, if there is only one interpretation is there, now we will see. If there is only one interpretation that is conflicting, then the court shall implement the fundamental rights over the directive principle of state policy, because Supreme Court is duty bound to implement the fundamental rights. So now, if a direct conflict would be there between the fundamental rights and the directive principle of state policy is concerned, when there is a head-on collision, and at that time either you have to follow only one, and the court will give that Supreme Court says that you have to follow the fundamental rights. That is the point. It is clear. So now we will see the in the case of another case law, Venkatramana Devaru. Venkatramana Devaru versus State of Mysore. The Supreme Court applied the rule of harmonious construction in resolving the conflict between the Articles 25 2b and Article 26b, small b, in the Constitution. And it was held that the right of every religious denomination or any section thereof to manage its own affairs in the matter of religion. So now, because India is a democratic and secular country, so each religion having, which is having the denomination, they manage its own affairs in the matter of religion is concerned. That is Article 26, small b says. So, 26b. It is subject to a law made by the state providing the social welfare and reform, throwing open to Hindu religious institutions. Let me see, because the people are asking for the admission, so I admitted them. Then I think somebody is calling, but this is now the time to speak with them. So I will tell them I will call it later. Um, So, come to the point here. 26b says clearly that every religion having its denomination follow their own ideals, and that is section is subject to the law made by the state, providing for a social welfare or reform, throwing open to Hindu religious institution of public character to all classes of sections. So that section 26b is subject to the Article 25, subarticle 2, class B. So at that time, when you say that we have to, coherence should be there between the two rights. It is clear that Article 26b is subject to the Article 25 2b, small b, of the Constitution of India. Thus, two articles are harmonized and conflict is resolved by the principle of harmonious construction. So, what I want to say, make it clear to you is there. If two articles on the same Constitution having the contradiction would be there, at that instance, naturally, it will put it subject to the so and so. So we do have freedom of speech and expression. It is clear the fundamental right, but there are also limitations are there. So limitations you have to follow it. Otherwise, then the right is not given as a full right. You have to harmonize them. So limitations are there. Even for the parliamentarian also, they cannot amend any law of their. They cannot amend the not any law constitution the way they want, because the limitation is put it over there for a remaining section also. They say you amend the constitution in such a way the structure of the constitution should not be demolished. The structure should not be taken away. The right of fundamental rights and regarding the such a structure of the constitution should not be taken away. That is the limitation they put it over there. So we have to harmonize them in that way. Let me come to the point of principle of harmonious construction is also applicable in the case of construction of provision of subordinate legislation. Even subordinate legislation also will use this construction, and which is given in the Sarsilk limited case law. So let me see the Sarsilk case law is concerned here. Uh, the government of Andhra Pradesh is the government of Andhra Pradesh case law. An interesting question relating to the conflict between the two equally mandatory provisions. So it's very interesting. So one section 17 subsection 1, then 17.1 and 18.1 of the Industrial Dispute Act 1947 is a good illustration of the importance of the principle that every effort should be made to give effect to all the provisions of the Act by harmonizing any apparent conflict between the two or more of the provisions. Let me see that. Section 17, subsection 1 of the Act requires the government to publish every award of labor tribunal within 30 days of its receipt, and by subsection 2 of the section 17 says the award on its publication becomes final. That is the section 17, subsection 1 says. Let me see the section 18, subsection 1. 18.1, what it says. 18.1 of the Act provides that settlement between the employer and workman shall be binding on the parties to the agreement. So, in a case where the settlements are arrived after the receipt of the award of the labor tribunal by the government, but before its publication, that condition is put it over there. The award should be published as per the section 17.1. So, at the time, the question was whether the government was still required under section 17.1 to publish the award when there is already the settlement was made. That is the question. Where the settlement is arrived after the receipt of the award, then the question they say that in construing these two equally mandatory provisions, the Supreme Court held that only way to resolve the conflict was to hold that by settlement, which becomes effective from the date of signing. The industrial dispute comes to an end because when the settlement is there, comes to an end. Then the question of award publishing will not arise, and the award becomes it fructuous and means useless and waste or invalid. That is the meaning of fructuous here, and the government cannot publish it here. Both the provisions are harmoniously constructed or construed, and conflict is resolved by applying the harmonious construction. So this is a very good example whether when the settlement was there, whether the award should be published or not. The answer is when the settlement is there, there is no question of any publication of the award as per the section 17 is concerned. So I want to see whether any other person is waiting for the yes, people are waiting admit, so I admit them. Yes, I admitted them. Now, yes, come to the point. The next, that is in MSM Sharma versus Krishna Sinha. Let me see how the conflict in this case law and how it will be resolved. Here is the Article 19.1a. That is the fundamental rights. I think it is a freedom of expression. Yes, freedom of expression. And Article 94, Subarticle 3 of the Constitution, it was held that the right of freedom of speech guaranteed under the Article 19.1a is read as a subject to powers or privileges and immunities of the House of the Legislatures, which are those of the House of Commons, like the United Kingdom, as declared by the later part of the Article 194 Subarticle 3 of the Constitution of India. So if you take an example of this thing, everybody is having the freedom of expression and speech, but subject to the we should not make any allegations toward the speaker. We should not make any allegation because he is having the privileges, president, and some restrictions were put it over there. And not only the restriction, that restriction, if you defame any other person, if you say that I do have the freedom of speech and expression, if it comes under the definition of the defamation, yes, and he will file a case, a defamatory suit against you. So every expression having its own limitations. So we have to harmoniously made it, and we should not speak whatever you want against anybody. So that restriction put it over there, even by the Constitution also under the Article 194.3, even though freedom of expression is given in Article 91A, small a. So I hope that you got my point. So let me come to the conclusion. Far is concerned, statutes are crafted by the legislature, and there is every possibility of situation of ambiguity, conflicts, anomalies, absurdity, hardship, repugnancy, redundancy, etc. In such situation, the rule of interpretation of statute comes into play, and the provisions are construed as to give the maximum effect to them and to render justice to the situation at hand. So the principle of harmonious construction plays a very important role in interpreting statutes and is used to in abundance of the cases. It helps in simplifying the complicated issues and make delivery of the judgments much easier. Therefore, like the many rules of interpretation of statutes, the importance of the rule of harmonious construction is also understood and felt by the judiciary. It was rightly said by George Washington, the administration of justice is the firmest pillar of the government. So, administrative justice also firmest pillar of the government. Thus, in keeping with this thought, the judiciary should interpret the statute properly and intelligently, apply the rule of the interpretation of statute to render the quick justice to the citizens of the country. The courts in every case harmonize the contradictory provisions by interpreting not only the provisions but also the original intention of the law or rule maker in order to give effect to both the provisions of the same statutes or the different statutes are concerned and ensure not to make any of the two provisions void or to destroy it. So, like with this, I would like to end my lecture. Then I will feel happy. Thank you very much for patiently listening without causing any disturbance to my class by shutting their audios and videos close. And now I will give the chance for the participants to speak. And now let them speak. I could hear their voice. Yes, I could hear your voice. You can speak now.
Hello.
Yes. Yeah, one can speak. Yes. MA server. Yes. Oh, who are not? Only one should have to speak.
Sir, Seshavdar is speaking, sir. Seshavdar.
Sheshavartaram. I will give the chance, but other people are there.
Okay.
A server is there on the line, so I will give the chance to server. Then I will give the chance to you. You keep very close to your mouth so that I could hear your voice.
Myself, sir.
No, server. Yes, server. What is your clarification you need? You can chat also. If you have any problem, you can chat and show your problem so that I could clarify it. Yes, Sheshavataram, now you can speak.
Sir, here one clarification, sir.
Yes, please.
If the disharmony in between two acts or within the act, the provisions of the act is coming due to the overlapping of the provisions or what?
See, if two acts are contradicting to each other, so the court will take the discretion whether to which act should be followed and which act should be eliminated, which act should be given the preference. So it is the discretion of the court to see that the parties should get justice. That motive they will keep in the mind, and they will use the such statute which is beneficial to the parties at that instance. And otherwise, if they could harmonize between the two, yes, they can also do that too. They can harmonize them and give the judgment in that way. But it is very difficult for the parties to harmonize them. At that instance, they will follow one statute only, and they will make the another statute like a dead timber or a lumber. Yes.
So there is a contradiction of the provisions
Contradiction of?
of the acts.
Yeah, if the two contradictory to each other again comes, suppose one act says, dowry prohibition act says, you take the instance, this talaq is there, the triple talaq is there. They said it is made, but it is against the constitution, so it is a cut down. Not only this point, if you take any act which contradict the grand norm, that is the constitution, and such act is null and void. That is fine. Or any central act which is contradictory to the state, their central act will prevail. If there is a contradiction between the two provisions of the same constitution, like example which I gave, fundamental rights and directory principle of state policy, at that instance, they will take the only fundamental rights. For instance, I will give another example. Your father says, don't go outside. But your mother says, go outside. To whom you listen?
There's a contradiction.
Contradiction. So harmonize them. What we have to do is we have to convince, okay, I will follow today father's order and tomorrow I will follow your order.
Counseling.
Counseling it is harmonious. Suppose children says, sir, dad will see the English movie, and the daughter says, dad will see the Telugu movie, and there is a contradiction, and the wife says, okay, let them give the chance to them. At that instance, son is the elder, daughter is a younger. To whom you will give the preference?
Sir, one more doubt here, sir. Actually, one more doubt.
Okay, please.
So while drafting these acts, they will
Yes.
not observe any contradiction in between two provisions of the two acts.
Because
Yeah,
naturally what will happen, they thought in a different way and they drafted it, but later on they came to know. That's why before any act would be coming to existence, there would be a debate. There is proceedings. There is a white paper is given, and people will give the opinion, and people pass the comment.
sir.
All this will be taken into consideration. Then they will make an act. But still,
Sir,
there is a maxim is there. Errare est hominum. To err is human being.
yes.
Hence,
Because while drafting this ID Act of 1947,
okay.
as you were telling, there is a mistakes in the same. That means there is a contradiction of two sections or two subsections is there, no, sir.
Yeah, when the two sections say something, one section says something, then naturally, in that instance, we will give the benefit to that party, that section should be followed over there.
Because the very act is drafted by only must be by the same persons, no, sir.
Yeah, the same persons may be there. It doesn't matter. See, do you think that if the same person.
Similarly,
Uh,
so similarly, in the case of this sales tax or central excise act, what you were telling is the provisions.
yeah. See, always this conflict is there. Sale tax and central tax. To avoid that conflict, what they did it know, the GST has come over there. Now there is no contradiction. Otherwise, there very much contradiction would be there because the goods will produce it in one state and they transfer to another state. Then they have to pay the double taxation. At that instance, matter comes to the very tough sum. How much percentage, this percentage, that percentage. So now they say, no, better we'll make a one tax. The proportionate amount will give to the states if they are getting the revenue from there.
So complete Allah, bus.
No. First they will take it, next they will give you. First they will take it, and next they will give you.
पहले बना बाद में देखो चलो.
Yes. That is the principle. Like, पहले बंदो, बाद में लो.
ID, just like an ID act.
The tax statutes are there. First you pay. Suppose you will say that you paid the more because the exemptions are there. Okay, you claim the exemptions. Or you put the exemption first, then you make the tax return,
Yes.
whichever is possible way. So anyway, that time is 12:15, and if any other person wants to speak, you can speak it and raise the hand and give the chance. When you speak, you keep the speaker very near so that I could hear your voice. So otherwise, no, I could not hear you. Of course, it depends upon the here a statute, a construction of statute, and construction of statute. In both are different, or both are same, sir. Okay, please tell me, sir. Yes, very. That is a good way that you are. Statute and construction of statute. See here, statute is nothing but act. Construction of statute means when an act is made over there, the words used in the statute, how it can be construed. That is the construction of statute provisions. Like an example, generally I gave you, uh, you don't come late to my class. Don't come late to my class. Full stop. You may be penalized. You may be penalized there. May word is used there. May means discretion. That is written in the
Not so.
statutes. So now,
Not so.
when penalized it is there, the may is read as a shall. So
Shall.
there you say, you shall be punished, even though it is a may is written. That is construction of the statute. We construed, we replaced may and put the shall because it is a penal activity is there, penalized it is there, which is a mandatory. So statute is an act. Construction of statute means already construct statute in any provision or any word which is needs the interpretation, then the construction of statute will come. At that instance, we follow the principles. That is the literal rule, golden rule, mischief rule, purposive rule, rational rule, liberal rule, beneficial rule, harmonious construction. This is also rule, a doctrine. So, in what way that the court want a person who comes to the court should not go with the empty hands. That is the intention of the court. Yes, in both the difference I said it is both are different. Yes, both are same. No, both are different. Statute and construction of statute. A statute is an act. Construction of statute means the letters which you put it over there will be read as a different way. That is the construction of statute. So when you are constructing the statute, you should construct in a such a way there should not be any lenience. Strict construction of statute means it is constructed very strictly. Even though there are loopholes are there, yes, it needs the interpretation. Yes, any other thing? Yes, please ask me because we encroached at least 3 minutes on your leisure period. If anybody is there, if you could not, I could not hear you proper, you can chat like this. The chat is sent by one of the HK. He made that chat. Yeah. Okay. He said, thank you, sir. Yes. Please ask me. Suppose if there any problem would be there in your audio or in my audio would be there. And naturally, you can chat so that I could see the chat and I can give the answer orally because I cannot again type it, which takes the time consuming. So with this, I would like to say thank you to you with my slide because now I'm also becoming the yes. Thank you is already put it over there, which is then I will close it. Thank you very much again, once again, and have a good day and goodbye. See you tomorrow of the next topic, which is there in the syllabus. So I will stop
Thank you.
this meeting and I will close it. My meeting. Yes, end of the meeting.
Thank you.
Namaste and Jai Hind.